articles on state and federal administrative law, as well as comparative administrative law. Mr. Asimo holds a JD from UC Berkeley and a BS from UCLA. Welcome, Mr. Asimo, you're on the screen. And last but not least, Mr. Richard Tortzen is a senior counsel and a member of the patent litigation practice in the Washington, D.C. office of Wilson's Sonsini, Goodrich, and Rosati. Before joining the firm, Mr. Tortzen was an administrative patent judge at the PTAB, where he wrote more than 1,000 opinions and orders on patent appeals, petitions, motions, and briefs. Before serving as an APJ, Mr. Tortzen was an associate solicitor in the U.S. Patent Trademark Office of the Solicitor. Mr. Tortzen holds a JD from the University of Texas Law School, an MS in biotechnology from Johns Hopkins University, and a BA in computer science from Rice University. Welcome, sir. Before proceeding with testimony, I would like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and that any false statement you make today may subject you to 18 U.S.C. Section 1001. Before turning to our panel of witnesses, without objection, I will enter a statement from Andrew Foyce, Chairman of the Administrative Conference of the United States, an independent agency in the executive branch charged by statute with making recommendations to the President, federal agencies, Congress, and the Judicial Conference to improve agency adjudication, rulemaking, and other administrative processes. I would also like to note that we have a statement from the U.S. Patent and Trademark Office responding to the GAO's initial findings, along with information about some new interim processes they have put in place. Now, turning back to our witnesses with us today, please note that each of your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light on your table, and when the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it means that your 5 minutes have expired. We will have 5-minute rounds of questions after the witnesses' testimonies. Ms. Wright, you may begin.
Chairman Johnson, Ranking Member Issa, and members of the subcommittee, thank you for the opportunity to discuss GAO's ongoing work about management oversight practices at the Patent Trial and Appeal Board. It should be.
The microphones tend to need you to be pretty close in order to work. If you pull it a little closer.
How about now? Okay. Thank you for the opportunity to discuss GAO's ongoing work about the management oversight practices at the Patent Trial and Appeal Board. Today, I will share with you preliminary insights from our survey of over 200 PTAB judges, as well as perspectives from external stakeholders on PTAB oversight practices. Over the years, various USPTO directors, with input from PTAB management, have introduced oversight practices to achieve consistency and quality decisions given the increasing number of judges. Oversight practices have included review of the judge's work before and after decisions are issued. While judges generally acknowledge the need for some oversight to promote consistency across decisions, our preliminary work identified concerns among PTAB judges about the increasing levels of management oversight. Many of the central oversight practices have been formalized into policy over the last 5 years. These include a peer review committee of non-management judges who reviewed AIA institution and final written decisions before issuance. In addition, PTAB established a process in which management conducted pre-issuance reviews and provided comments on decisions that involved issues of interest, such as new legal or policy areas, or areas of inconsistency with other PTAB decisions or USPTO guidance. PTAB management officials told us the comments provided as part of management and peer review processes were generally optional for judges to adopt. In our work, we found that 2/3 of judges who worked on AIA trials and 1/3 of judges who worked on ex parte appeals reported feeling pressure to change an aspect of their decision due to management review comments. Based on our survey and interviews, some judges reported the increasing amount of oversight and guidance contributed to a sense of pressure that goes beyond cases in which USPTO directors or PTAB management were involved. While judges may have reported feeling pressure, they noted oversight typically did not influence the merits of the case. However, there can be pressure on discretionary areas driven by agency policy or guidance. The concerns raised by PTAB judges signal potential cultural issues. Some judges noted that even though they personally have not been on a case in which management or a director had directly intervened, they heard about situations involving other judges, which then made them feel pressure as to how to render their own decisions irrespective of management's involvement. One judge stated that the very existence of the management review process creates a preemptive chilling effect. Some judges noted having minimal insight about certain management practices, including who in management is reviewing and commenting on decisions. We also spoke to various stakeholders who generally valued PTAB's ability to resolve patent disputes with specialized patent judges. Stakeholders were generally unaware of the management and peer reviews, except for some who had heard of them anecdotally or because they were former PTAB judges or officials. Most stakeholders were concerned about the lack of external transparency on how decisions are made within PTAB and the extent to which certain decisions were solely those of the 3-judge panel or whether others had influenced the decision. Some sitting judges also echoed this concern over external transparency, noting that when management influenced a decision, there would be no record in the issued opinion. One judge noted that such insights could help parties to a case decide whether to appeal or to request director review. In closing, I note that during the course of our review, PTAB recently announced a new interim process for decision circulation, which replaces the previous peer review committee. The new interim process would make use of a circulation judge pool of non-management judges. However, this judge pool will not consult with management about a decision prior to issuance. Under the new process, management review will be voluntary, and it will be optional to implement comments. Also, the director will not be involved in directing or influencing decisions prior to issuance. Officials noted the new process was put in place as a means to promote transparency about decision-making in PTAB. This could be a good step forward to address concerns of judges and stakeholders. We will examine the implications of the new interim process as we complete our ongoing work. Chairman Johnson, Ranking Member Issa, and members of the subcommittee, this concludes my remarks. I'd be happy to answer questions you may have.
Thank you, Ms. Wright. Mr. Smith, you may begin.
Can you hear me now? Wonderful. Chairman Johnson, Ranking Member Issa, esteemed members of the committee. In 2011, at the recommendation of then United Undersecretary and Director David Kapos, I was appointed by then Secretary of Commerce Gary Locke of the Commerce Department to serve as the Chief Administrative Patent Judge of the Patent Trial and Appeal Board the Board of Patent Appeals and Interferences of the United States Patent and Trademark Office, the BPAI. I was the last person to serve in that role. And as you all well know, the BPAI was transformed by the enactment of the AIA to become the PTAB. With that change, I was asked to serve as the first inaugural chief judge of the PTAB. At the time of the AIA's enactment, the BPAI had an ex parte case backlog that eventually rose in 2013 to 27,000 appeals arising from within the PTO. And with the task of reducing that backlog also came the task of equipping the PTAB to handle the new AIA jurisdiction. We expected to be added to our workload about 400 new trials every year. The predicted rate of 400 new trials per year turned out, as you know, to be in excess of 1,500 new trials, or at least that many trial petitions, every year for the next several years. At the time of this transition situation, the new PTAB comprised about 90 APJs, and because of strict preclusions on hiring in the federal government at the time, only those 90 judges were supposed to reduce the 27,000 case ex parte backlog, even as 7,000 new ex parte appeals were being filed every year, and then also adjudicate 400 new trial proceedings annually, which, as stated, actually turned out to be 1,500 new trial matters per year. David Kapos petitioned for and quite fortunately received permission from this Congress and the White House Budget Office for us to be allowed to expand the board. We needed at least 150 additional first-rate patent judges, and we needed them to be nominated, selected, and appointed quickly. Accordingly, the chief APJ, to whom oversight of such selection and nomination duties fall, needed to oversee and drive the necessary process while also ensuring that the regular judicial duties of the tribunal proceeded smoothly. In consultation with Director Kapos, we constructed a process that endeavored to select for nomination to the Secretary of Commerce the people thought best by us to discharge the duties. As mandated by the statute, we sought to add to the fine judges already on the board 150 individuals who were of unquestionable technical and legal qualification. We looked for the best PTO employees qualified to serve, and we heavily recruited from outside the PTO, including by looking to the ranks of former judicial clerks who had served earlier in their careers under Article III judges at the federal district courts and the courts of appeals. We don't have time this morning to go into all of what the proceedings for the selection included: writing samples, interviews of recommending individuals, interviews of the candidates themselves, and also numerous hearings, mini appointment hearings for the judges. One thing to focus on perhaps for this morning is the one question we asked all the candidates, and it went something like this. It is early evening one day in the work week, and the undersecretary or one of his representatives has slipped into your office to discuss an opinion you are drafting for a case which was heard or is being heard by the panel. This person says to you that because of political considerations, facts known only to the director, some impact on the marketplace, that the director wishes the case to be decided in a way other than how the panel is prepared to decide the case. What will you do? Every one of the judges who we advanced for nomination answered that question only one way. We will ask whoever is asking us to change our decision to leave because we believe in judicial independence and due process, and the director has other means, including through rehearing, for the case to be reviewed. All of the candidates who said they would do whatever the director told them to do were not advanced in the process. I speak to this largely to say this one thing. From at least that time through now, my belief is that all the judges in their hearts and souls have a commitment to judicial independence, and whatever may be incident to the process now, I think none of that will have changed what they seek to do in the carrying out of their jobs. If the hearing allows later on, the one other thing I'd want to touch on is the mention by the GAO report of the ARC, the first of the review mechanisms that is mentioned in the report and about which I think I also can offer some historical perspective.
Thank you. Mr. Asimov, you may now begin.
Good morning, and thanks so much for inviting me here today. So the reason I got invited was because of an ACUS study that I did about 5 years ago about adjudication outside the Administrative Procedure Act, of which there is a great deal in the federal government, and the PTAB was one of my prize exhibits. Now, in fact, there is a question about whether PTAB is covered by the Administrative Procedure Act, which I don't have time to discuss. We're happy to turn to it in the question period. The problems that we're all talking about today all arise from the defective structure of the PTAB when it was first created, because unlike any other system of adjudication in the federal government, there's no appellate process within the agency. It's very unusual, and it created a crisis because there was no way for the director to manage the decisions of hundreds of patent judges. And so various suboptimal solutions were adopted to try to achieve coherence, consistency, and to carry out the policies of the director of the USPTO. So I'm not going to have time today to talk about whether we should restructure the PTAB, although again, happy to answer questions about it. I want to defend some of the measures that the PTAB took on a managerial level. First, I'm in favor of the use of precedent decisions. These are used across the federal government and a very useful method of achieving consistency in adjudication. So I think those are just fine. The adoption of guidance documents, which are regulations that can be adopted without going through notice and comment to settle policy questions, is extremely useful and probably should be more utilized by PTAB than it is already. I'm in favor of peer review systems, including the new innovations in that. It's perfectly okay, in my point of view, to have some judges critique the work of other judges, even before the decision becomes final. But the issue here for us today is management review, in which the GAO report makes it clear that management frequently intervened in pending cases. The judge, and as a practical matter, the judges were intimidated and chilled and mostly followed the suggestions of management, which were really commands. So I think this violates a number of basic administrative law norms. First, the lack of transparency. It just isn't fair. The director's interference favors one of the parties to an inter partes proceeding against the other, and yet the person on the losing side doesn't know what that input was and has no opportunity to rebut it, nor do you really know enough to decide whether to appeal the structure. In addition to that, I believe the management interference violates the rule against ex parte communications. And in particular, I call attention to a regulation adopted by PTAB, which says ex parte communications regarding a specific proceeding with a board member is not permitted unless both parties have an opportunity to be involved in the communication. I think that regulation has been flouted by the management interference practice. It violates the exclusive record principle, which says that a judge can only consider what is in the hearing record in making the decision. And in general, it violates the principle that administrative judges in our system should be independent in law, in fact, and appearance. And management interference prevents that from happening. Now, I know all of this arises from the lack of a proper appellate mechanism, which was a very serious defect in the AIA, and has been remedied to a degree by the Supreme Court's decision in Arthrex, which says there has to be an appellate mechanism. But so far, none has been created. Simply giving the director power of interim review over all the hundreds and hundreds of cases flowing through the agency is not adequate. There needs to be a structure of APJs who are creating an appellate tier within this agency, with then perhaps discretionary review by the director. Still, as better appellate review is instituted within this agency, I hope that the need for management interference will be greatly lessened. So I'd be happy in the question period to discuss possible changes, restructuring of the PTAB, as well as its interrelationship with the Administrative Procedure Act. So thanks very much for the opportunity to comment on the PTAB.
Thank you, Mr. Asimo. Mr. Tortson, you may now begin.
Good morning, Chairman Johnson, Ranking Member Issa, and members of the subcommittee.
this better?
Okay. Thank you for inviting me to provide my views on the Patent Trial and Appeal Board. My involvement with the board spans over 3 decades, including nearly 2 decades as an administrative patent judge, deciding appeals, managing trials, and drafting board rules. I now practice mainly before the board representing patent owners, petitioners, and appellants. Please note that I speak only for myself, not for my law firm, not for my clients, and not for any other organization. My written statement is of record and provides content and support for the points I will summarize today. First, tension inherently exists between political accountability and adjudicative independence. In Arthrex and other recent Supreme Court decisions, the court has favored political accountability for various textual and structural reasons. For purposes of this hearing, I assume Arthrex is correct in controlling. Second, political interference is not new. What has changed, however, is the frequency and scope of that interference. Previously, political and management interference were rare and always recognized, at least at some level, as improper. Now it is routine, so routine it's become institutionalized. The AIA accelerated the erosion of an ethos that's embodied in the Administrative Procedure Act, which sets the norm for agencies. For example, the current layers of pre-decisional review is a new concept with predictable chilling effects. In fairness, most such interference does not directly affect the merits. However, critically, even minor interference creates a ratchet effect such that once some interference becomes the norm, more follows. From the outside perspective, there are at least 2 problems with this. First, parties, courts, Congress, and the public never know whether or how much interference has occurred in a given decision. Nothing's preserved in the case record, and no internal communications are preserved for archives. Second, flouting one administrative norm leads to flouting others. For example, Congress defines a rule as an agency statement of general or particular application and future effects. Board precedential decisions clearly meet this definition, yet they do not comply with any of the statutory rulemaking requirements. This rule by fiat is particularly harmful at the institution stage, where lack of judicial review enables unchecked departures from administrative norms that stakeholders cannot challenge. Several possible solutions exist. The simplest is simply to codify transparency. Congress could require that all ex parte communications initiated from outside the panel must be made of record. Alternatively, many have suggested creation of an independent review level. We should acknowledge the cost of diluting the director's important policy role by creating yet another source of patent authority. Unfortunately, however, it might be needed to ensure the board adjudications will occur on the merits and on the record. Review authority should be distributed over enough reviewers to be practical. Vesting all review responsibility in a single reviewer is facially impractical and would evoke the same skepticism that the Supreme Court's Arthrex decision has prompted. The review authority should stay in its lane and not compete with the director's policymaking. Review authority, especially if located inside the USPTO, must have budget protections and other comparable assurances of actual independence. Finally, if APJ work is subject to additional internal review, the rationale for 3 APJ panels dissipates. Congress should consider whether single APJ trials would facilitate other process reforms, such as faster trials and live testimony. In conclusion, thank you again for inviting me here today. I look forward to your questions.
Thank you, and I thank all of the witnesses for their testimony today. We will now proceed under the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes. Ms. Wright, the GAO's testimony suggests that many administrative patent judges felt pressure to change their decisions in response to direction from management. Based on your team's research, was this direction from management always made in writing? And if not, and can you also tell us what other forms this direction took?
Certainly. I would say with respect to the comments that were received during the management review, it really was a mixed approach. It did seem, however, that most of the comments were actually not in writing, and what we discovered that through our discussions with the judges as well as with PTAB management. Sometimes it might have been a phone call, somebody walking into someone's office to have a discussion, but certainly there were not a lot of documented comments that were provided from what we learned.
Thank you. Mr. Tortson, from the GAO's testimony, it seems that the administrative patent judges on a 3-judge panel are often contacted by others at the agency about that case. Yet there is an existing regulation that prohibits ex parte contacts with APJs. Are you aware of this apparent tension while you were at APJ?
Thank you. As the person who drafted the rule in question, I can assure you that it has never been viewed as having internal application. Having said that, I would like to clarify. I mean, a typical appeals judge is deciding, I mean writing up about 100 cases a year and participating on another 200 as a panel member. The number of cases in which there's actual interference is pretty small. So I don't want it to seem like this is happening in every case. The problem, of course, is that it's happening at all. It has 2 effects. One is it's a real problem in the case where it does happen, and it's also, it does have a chilling effect because, particularly on certain hot button issues like 101 patent eligibility, there's an excellent chance that if you are not saying things exactly the way they're supposed to be said, or you come out with a result that you think is right on the merits, but maybe doesn't fit in the right pigeonhole, you may get a visit, you may even be asked to change your opinion.
In light of the rule against ex parte communications being in place at this time, do you think legislatively mandating no ex parte contacts with APJs would go far enough to ensure judicial independence?
I absolutely think legislation would make a difference. Among other things, it would give clear empowerment and a clear sense of policy direction to the agency of what's supposed to occur. It would also, as a practical matter, give the APJs employment recourse if they're criticized at that point. I think largely this comes down to a matter of culture. In a perfect world, we wouldn't need this because in a perfect world, people would understand that the existing administrative norms already require what we're discussing. I think the problem is culturally, we're well past that point.
Thank you. Professor Asimo, one of the issues highlighted by the GAO is that administrative patent judges sometimes face lower performance reviews or reassignment if they do not accept management-directed changes. How do other agencies handle this sort of dynamic in an adjudicatory setting?
Well, if you're covered by the Administrative Procedure Act, there are various elaborate protections for administrative law judges, and who, if they're subject to any kind of unfavorable employment action, can take that to the Merit Systems Protection Board. Now, this doesn't exist when you're outside the APA, and therefore it is more difficult to achieve judicial independence in the situation that you described. There isn't any clear-cut remedy for the APJ to pursue if they suffer some sort of a negative employment result. It's a big problem and obviously undercuts the goal that administrative judges must be independent.
Thank you. My 5 minutes have expired. We will now turn to the gentleman from Kentucky, Mr. Massey, for 5 minutes.
I thank the chairman. I wasn't here for the AIA, so kind of looking back in history, but was part of the reason that it was established was that the stakeholders wanted more certainty in the outcomes, that maybe that juries weren't capable of adjudicating patent validity. Was that part of the motivation that a layperson, selected to be on a jury might not come up with the right answer? And I'll ask you, Mr. Smith.
Can you hear me? Yes. I'm not sure that there was, well, let me answer the question this way without speaking to juries specifically, because of course, in going to the AIA, one not only avoids a jury, but a bench trial from a federal district court. And
If you could speak about juries, I'd appreciate it, because that's my next question.
It's subsumed within the answer. Generally, well, the statute requires the judges of the PTAB to be both technically and legally qualified, and only they participate without any jury in the decision of the case. So one necessarily gets with a PTAB proceeding the elimination of any uncertainties one might think a jury to introduce to the proceeding.
Would you like to comment on it, Mr. Torkson?
Yes, I think that there was an understanding that issues outside the technical or legal merits could influence the decision of any decision maker, and that one of the advantages of having an expert body is that they would be familiar with the technology. By statute, APJs are required to be, and usually practice within, or usually are deciding cases that are aligned to their area of technical expertise. Plus, APJs decide far more patent cases than anybody else, even federal circuit judges. And so as a consequence, are always very acutely aware of what the state of the case law is. I think the expectation is you would get advantages and efficiencies by having people who are directly familiar with both the technology and the law, which might be lost on others.
Thank you. So just looking back, I wasn't here for the creation, but I find it odd that we created this panel that would invalidate patents because the juries weren't capable of understanding this, but infringement is still decided by juries, right? Isn't this true that PTAB doesn't deal with infringement?
That's quite true, and in fact, even invalidity is still typically, or often handled still in court.
So I think it's kind of odd. I don't understand why this is a one-way system where if you're an inventor, the only thing that comes out of PTAB, the only possible outcome that's an active outcome is your patent's dead. But if you're an inventor and somebody's infringing on you, the PTAB doesn't, there's no offer of help there, and we say we can trust juries with the decision of infringement, but not with the decision of patent validity. But in fact, they involve exactly, not precisely, but very largely the same issue. Do you believe that patent holders should, at least even after PTAB, always have the right to a jury trial?
I have to unpack that question a little bit. I mean, certainly if you are in district court.
Should they be able to appeal it and get a jury trial?
So you're proposing appeal of an administrative decision to a district court with a jury trial. I would say that goes to a more fundamental issue because that would be unique in review of
here's the problem that I have. There used to be a provision in our parliamentary rules on the floor of the House where you could rename a bill. And I once offered an amendment to rename the bill to suspend the debt limit 2 years, a bill to kick the can down the road and for other purposes. I only got 40 votes on that amendment. But if I'd been here for the AIA, I might have offered an amendment to rename it the 7th Amendment Repeal Act, because this thing that's in our Constitution, which is the right to a jury trial, if the thing in question is more than $20, has been suspended by AIA. And I know my time's expired, and I don't want to start us off on a bad foot, so I yield back to the chairman.
It was a wonderful foot. I felt it.
Thank you. We will now turn to the gentle lady from North Carolina, Ms. Ross, for 5 minutes.
Thank you, Mr. Chair, and thank you to the ranking member and all of the witnesses for being here today to discuss this very important issue. I represent a district in North Carolina that takes pride in its culture of innovation. My district is home to world-class research institutions, individual inventors, small startups, large technology companies, and everything in between. Innovators deserve to have their rights enforced in a transparent manner, consistent with the principles of due process. And that's why the GAO's preliminary findings are so troubling. 75% of the surveyed judges responded that the oversight practiced by the politically appointed directors or other PTO management had affected their independence. This is unacceptable and contrary to the fundamental values that undergird our democracy. The integrity of the US patent system must be maintained to ensure continued American innovation. My first question is for Mr. Smith. As the inaugural chief judge who oversaw the agency's transition from the Board of Patent Appeals and interferences to PTAB, your written testimony states that you sought to enshrine due process and lack of interference. Can you talk about your vision of how the board was meant to function and how that compares to what we've heard from the GAO today? Please also highlight what you believe are the root causes for those differences.
To the first part of your question, I'll offer these two things. First, somewhat in distinction to what Judge Torkson has said, I think, at least at the time I was at the board, the idea that there should be no ex parte communication operated not only with respect to ex parte communication coming from outside the agency, but also from within the agency, that the three judges empaneled to hear a case were to be hearing it by themselves without interference or discussion or contribution by any others inside or outside the office. Secondly, I would say this, and this touches on the portion of my testimony that I had hoped to provide a little more insight around, namely the operation of the ARC. The ARC was intended not to be an ex parte communication or other interference by other judges, including management judges, with respect to the merits of the decision, but merely one to drive uniformity in the written output of the board. And in fact, it was the case that members of the ARC sometimes provided to judges recommendations about how strongly they might state their opinions, even when those opinions were the opposite of what an ARC member might himself or herself have wanted to decide. So that is at least some of how historically we tried to drive independence, transparency, and the absence of interference in communication about cases.
Thank you very much. And Mr. Torkson, as a former judge who now represents litigants appearing before PTAB, how do the GAO findings comport with your personal experiences? And do you find any of those findings particularly surprising?
The first answer is they are very consistent, not only with my experience, but also with what I hear from currently serving judges. And no, none of them were surprising. Again, I think the report shows that there is a problem. It's not in every case, but the lack of transparency makes it a problem because you never know when it's an issue.
Okay. And then where do you think, why don't we go to this next one for Ms. Wright very quickly. Thank you for your work to shed light on this critical issue, and I understand the final report will have recommendations. Are those recommendations limited to the recommendations for the PTO, or will you have some legislative ideas that go with that?
At this time, based on the findings that we are reviewing, it will likely be recommendations to PTAB or to USPTO. We think that there are certainly some issues to look at with respect to transparency, communications, and so those will be some of the things that we will continue, excuse me, to develop as we complete our work.
Thank you, Mr. Chair. My time's expired and I yield back.
Thank you. Next will be the gentleman from Ohio, the ranking member of the full committee, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. I would yield to the gentleman from California, Mr. Ice.
I thank the gentleman. Ms. Wright, you said that you thought this would be primarily the PTO, but if you make recommendations and they make changes without legislation, would there be any reason they couldn't simply change back later?
I mean, that's certainly a likelihood based on what we heard from the judges and others who we spoke with. Different directors take a different approach. There's some of them that are more heavy-handed, some that are a little bit more hands-off. And so there's probably a need to think about ways in which to ensure that there can be consistency regardless of who the director is.
And following up on that, Mr. Smith said that in the interview process, candidates who failed to say, "Get out of my office," were not selected. But in your interview process, did you find people who in fact admitted that they made changes that based on these ex parte effectively orders to make changes?
So while we did hear from people that there were directions to, or comments provided that could alter or modify their decisions, none of the judges who responded to the survey or those we interviewed admitted or stated, I should say, whether or not they subsequently adopted those changes. They certainly noted that they felt pressure to do so. They felt an obligation, particularly if it had potential repercussions on their performance reviews, but we did not hear specifically whether or not those changes were actually adopted.
I don't think I would admit it either, but following up on what Mr. Smith said, they did not throw the man out of the room. They did not ask him to leave, and they felt pressured. So at a minimum, it could have had an effect on their decision process without a doubt.
It's possible, but hard to say since we don't have the evidence, testimonial or otherwise, to show.
In at least one case, did the director actually make reversals in an ex parte and undisclosed fashion?
I'm sorry, can you repeat?
Did you find cases that were reversed in any case by the director, period? In other words, they made a preliminary, it was reversed, and the indication was it was on orders of the director.
Nothing in our work.
But you saw cases that got reversed after a preliminary, you just couldn't prove that who did it.
We did not know, we couldn't say definitively what changes were adopted and whether that resulted in an actual reversal. Judges noted that they got comments, they felt pressure, they felt obligated, but we did not have the information to definitively confirm.
Mr. Torzen, I knew you'd be chopping at the bit. Let me just ask one preliminary question, which is, if you were an Article III judge and someone walked in the room and had an ex parte discussion about how you should decide it, is there any question about what would happen if you walked in to see an Article III judge with such a, even if you were a Fed Circuit judge, what would happen?
I think the result would be very different. And in fact, I think this gets to a point that there actually is an internal review process at the Federal Circuit, but there's a huge difference between a staffer offering a suggestion to someone with life tenure and a supervisory or even supervisor-supported colleague giving you advice on how to write a decision when you're not life tenured.
You know, especially when your career could be affected by that same person.
Right, and I mean, sometimes the effects can be really subtle too. I mean, if there are two dispositive issues in a case, one of them is a hot button issue like Section 101 and the other one isn't, I may choose to decide the case on the issue that's not dispositive and try to avoid the 101 issue entirely. Plus, I can give you at least one example from my experience where I was on a panel One of the judges was a management official. I indicated I would dissent, and the next thing I knew, the case had been assigned to a different panel. So sometimes it can be fairly heavy-handed.
And there won't be time for you to answer this one, but when we get another round, I want to make sure that both you and Mr. Asimo are prepared to talk about your divergent decisions, because he felt that circumventing APA was okay and necessary, and you seem to feel that without rulemaking, the process effectively was not what Congress had intended in the law. And you can just say yes.
Yes,
we'll get back.
yes, I look forward to that.
Thank you. Yield back. I thank the gentleman.
Thank you. We will now turn to the gentleman, Mr. Stanton from Arizona for 5 minutes.
Thank you very much, Chairman Johnson. Thank you for holding this important hearing and substantive hearing. I know you have additional questions you'd like for the witnesses, so I'll yield my time back to you, Mr. Chairman.
I thank the gentleman.
Okay.
Ms. Wright, the GAO study required you to work closely with the USPTO and the PTAB management. Can you explain how your interactions with them went, and did you have any concerns that you were not getting the information that you needed?
Well, indeed, we did have several meetings and conference calls with them, and I would say in the beginning, it took a little bit of attention and effort to grease the skids, if you will, but over time, as the work continued, we were able to get information. Sometimes there were multiple discussions about various document requests, but overall, I would say in the end, they were responsive to our requests for information.
Did you have any concerns that you were not getting the information that you needed?
There was nothing obvious that would suggest that anything was being withheld from us. Sometimes it did take a little while to get the information that we were requesting, but in the end, to the extent that it was available, we did get the information. One of the things we did ask about was whether or not there were written comments that were provided and examples that could be shared, and that was something that we consistently heard that there weren't really many written comments to be able to provide to us.
Is there any information that you believe that you should have gotten but you have yet to receive?
Nothing outstanding comes to mind at this time.
Thank you. Mr. Torson, your testimony suggests that there was a culture of judicial independence when the PTAB was the Board of Patent Appeals and Interferences. Where do you think that came from, and do recent developments suggest that this was more of a norm than a legal or regulatory requirement?
I think there were several factors that went into play. First of all, when I joined the board in the mid-90s, patent law just was starting to become a highly visible topic. So I think we've seen an increasing politicization of the agency since then. I also think that one way that the AIA directly contributed to this is it forced a very quick tripling of the size of the board. I think Chief Judge Smith deserves enormous credit for managing that process. That's a crazy growth curve. But I think one of the things is when I started at the board, overwhelmingly people were coming from within the government, either the PTO or other agencies. And so the understanding of the basic norms of agency practice existed, while bringing in a lot of people from outside of the government had undoubted benefits. One of the consequences was a weakening of that norm. Plus, at that time, they converted the position to have a 2-year probationary period, which meant your first 2 years at the board, you also had less job security. Whereas if you were coming in, from another part of the PTO, you pretty much had job security right away. So I think there are a lot of factors that fed into this, but there was no watershed thing, and it's not like the AIA flipped a switch or anything. I just think the culture drifted over the years.
Thank you. Mr. Smith, I wish we had time to hear about how you were able to clear out that backlog, if you were able to, and incorporate the new volume that was coming in. That's a story for a book, I suppose. But from my vantage point, part of the problem seems to be that APJs are legal and technical experts capable of reading and digesting binding precedent from the Federal Circuit and the Supreme Court. Therefore, if the director issues legal guidance on a contentious issue of substantive patent law, APJs may legitimately think that guidance departs from binding judicial case law. And as we know, the USPTO has no substantive rulemaking authority. In your view, how should this situation be handled?
A panel judge never wants to have, by following agency guidance, not followed Federal Circuit or Supreme Court law. So I think, and this was the subject of often discussion, we always undertook to take note of any guidance from the director's office, and certainly to allow it to guide us, but always with the thought that any written decision goes to the Federal Circuit, and the Federal Circuit never would say, while you didn't follow our precedent, we affirm because you followed the guidance of the director. So always the mandate was that the North Star's Federal Circuit and Supreme Court jurisprudence.
Thank you. Okay, we will next hear from the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Mr. Chairman. I yield my time to Mr. Massey.
I thank the gentleman from North Carolina. Mr. Torson, I realize the answer to the question I'm about to ask could take all day or all 5 minutes, but I wanted to give you a chance to give me a brief answer. In the beginning, in your testimony, you said for the purpose of this hearing, we'll assume that Arthrex, we'll go along with Arthrex. Does that imply that you have some disagreement and that maybe you think the Supreme Court didn't get it right?
I think that the place they came out saying that political head of an executive branch agency should have a significant role in outcomes is a very reasonable one. And I'm sure their reasonable minds can and do differ, but I'm not a Supreme Court justice. I'm satisfied with that result. I think we're here today because their solution isn't a particularly good solution.
Their solution's not a good solution. Okay. Mr. Smith, how about you?
I think the Supreme Court, and for that matter, the Federal Circuit, put forward two clear alternatives, both of which are, I think, constitutionally and legislatively acceptable. Presidential appointment without a significant review by the director, or for inferior officers, no presidential appointment but review by the director, which then triggers the next important and critical question: what kind of review, and is it a review of a kind that eliminates ex parte communication and allows transparency? So it's a fine solution if properly executed.
So all these problems that we're grappling with and all of the things that Ms. Wright has showed us here, how did we avoid this for the first 250 years of our country? The problems of, where the judges at PTAB don't feel like they have independence. How did we avoid that for the first 250 years of the country in adjudicating patents?
Well, of course, the development of the administrative and agency estate within the government is a long one, and in the late 20th and early 21st century, we have problems of that kind that we never had in the first 200 years because government wasn't that size. The primary protection was of the kind we have in Article III courts, appointment by the president with the advice and consent of the Senate, and then no change of salary or firing for how you decide a case. Inasmuch as those protections existed also in the executive branch, we also had insulation from the kinds of problems dealt with by the Supreme Court in the Arthrex decision.
Do PTAB judges get bonuses? Do their salaries change based on their manager's appraisal of their performance?
At least for a time, and I don't know if it's true now, bonuses were paid to PTAB judges, but not at all based on how they decided cases, but how much decisional workload they were willing to undertake. And this is part of the story with regard to reducing the 27,000 case backlog. Essentially, we asked the judges to work extra hours in order to help reduce that backlog.
I'm going to ask unanimous consent to submit to the record a paper that's called Pecuniary Interests of PTAB Judges, Empirical Analysis Related to Bonus Awards to Decisions, which seem to find empirically that the ones who struck down more patents got paid more. And I think that's a problem. I mean, you said that the Supreme Court offered 2 solutions. There's actually a very good third solution, which is the solution we've had for the first 250 years before AIA. It seems like we're struggling with this problem because we took something that belongs in the judicial branch and worked in the judicial branch for 250 years and stuck it in the most political branch there is. There's no bipartisanship in the executive branch even. Yeah, Congress is very political, but at least there's some Republicans and some Democrats at all times. In the executive branch, it is political. And the judicial branch I'm just sitting here thinking, all of these problems get solved if you do one thing: put it back the way it was. Put it back the way it was. Otherwise, we will be here. We can patch this PTAB up, but we're going to be here 4 more years wondering about how the system got corrupted, how the independence was lost, why inventors are getting messed over and they have no way to appeal it. We'll just be back here again if we try to patch this thing up, and I'll yield back my time. Yield back.
Thank you. At this time, we will recess for about 15 to 20 minutes for votes that have been called. We should be back in about 20 minutes. Okay, the committee has gone back into session, and with that, we will now hear from 5 minutes, Mr. Gates.
Thank you, Mr. Chairman. Thank you for calling this hearing. I yield to Mr. Massey.
Thank you, Mr. Gates. Ms. Wright, I'm glad you did this study, and I wish it were complete. I'm not sure why we called you here without a complete study, but since it's not complete, and I'm not blaming you for that, I want to ask you a question about the stakeholders who were interviewed to make sure you got the full picture. Did any of the patent holders that were, stakeholders, were you able to interview any patent holders who had their patents invalidated at PTAB and then couldn't get judicial review after that?
Excuse me. I'm not aware of any such instances from the folks that we spoke with. It was a really small group of people, 23 stakeholders total, and I think just a handful of patent owners.
It may be too late, but if it's not, I think it would be helpful to talk to patent holders who feel aggrieved by the PTAB and weren't able, specifically the ones who weren't able to get any kind of review at a court of appeals beyond that. I just think it's un-American that we have a system like that where somebody they've worked all their life, they worked really hard on something, they invested their time and their money, in some cases mortgaging their businesses and homes, and then they get, and what we found out today, they get, in a very non-transparent way, they get told, we're just going to take that all away from you, and then what happens is they appeal it to the court, and then the court has this thing where they say, well, we're going to agree with PTAB and we're not going to we're not going to re-litigate, we're not going to go back and look at what they did. Every time an inventor comes in and says that to me, I'm like, how can this be in this country? Mr. Smith, do you think that inventors deserve at least another review of their case in the Article 3 courts if their patent is invalidated by PTAB?
Yes.
And are you aware of any cases where where the higher court just refuses to actually look at the facts in the case?
I think the structure of the AIA made it so that if no trial is instituted, that decision is not reviewable. If a trial came to be instituted and the claims were declared to be unpatentable, my belief is the AIA most definitely creates a review structure within the Article 3 courts, first to the Federal Circuit and then to the U.S. Supreme Court.
Well, what I'm hearing from inventors is the higher courts just refuse to review the facts.
That's not my understanding.
Okay.
My understanding is that the Article 3 courts who review the decisions of the PTAB have the same review of facts that they have in other cases under a higher standard, of course, than they review the law, where that is reviewed de novo, but they certainly have available to them the opportunity to declare the work of the PTAB to have been in error with regard to any fact-finding.
There's a patent holder, or used to hold a patent, sitting behind you, who had her patent stripped by PTAB and hasn't had that, what seems to be the right of any American, extended to her to have an actual review of the facts of the matter in the case. I think that's problematic. Mr. Torsen, is it possible to patent a perpetual motion machine?
Unfortunately, yes. And in fact, I had a friend who once took a tour of the European Patent Office where they proudly showed him their collection of U.S. patents to perpetual motion machines, which was the entirety of their art on that subject.
Well, I think what Congress did when they passed AIA and created PTAB was they created something akin to a perpetual motion machine. When you get down in it, it can't really exist. You can't really have judicial independence, especially now, I think, in the context of Arsfrax. where they said there has to be somebody who's politically appointed, who's got at least some control over what's going on. And the problem with that is, even if it's not immediate and direct control over every patent review, it leans one way or the other, and that happens every 4 years, and patents last 20 years, and it shouldn't be this way, whether you believe in stronger patents or weaker patents. And I yield back the balance of my time.
We will now hear from the gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Chair. I yield my time to Congressman from California, Mr. Issa.
I thank the gentleman for his kindness and his yielding. Mr. Smith, earlier, quite a while earlier, there was a discussion about should you, having had a decision by PTAB, should you be entitled to a jury trial? There was also a question by a gentleman from Kentucky about this whole idea of being able to get back to what I understood was the district court if you didn't like what the PTAB did. Let's go through a couple of historic items, because the gentleman talked about restoring it as it was before the Invents Act. Do you get to have an Article III judge and a jury review if there's an ex parte reexamination and your patent is invalidated?
No, sir.
So that existed before 2011, still exists, right?
Yes, sir.
Okay, so administrative processes are decisions, because that's the entity. The PTO grants the patent. They also are the ones that can say we erred and new information changes our decision.
That is the current structure, yes, sir.
Okay. The only difference between an ex parte and the inter party is that the inter party is open and transparent, and if not interfered with, does have a high-level judge looking at it and making decisions based on evidence that is potentially rebutted if inaccurate.
Yes, sir.
Okay, now let's talk, though, about this jury question, because I think that's extremely important. Mr. Massey and I both have one thing in common, which we have a lot of patents and some patent experience, having been the litigants, if you will. Does the judge give the jury the Markman decision in an Article III court?
Maybe yes, maybe no. There's a certain amount of complexity to it. As a federal
Under Markman, is the Article III judge required to issue a Markman decision?
The judge is required to issue a Markman decision. There comes to be the question of how much is there in the way of underlying facts which drive the question of law that is determined at a Markman stage in a case. It could be that there are no facts in dispute, in which case the jury has no role in the Markman determination by the judge.
As a practical matter, and Mr. Terzon, as a practical matter, Markman decisions by the judge, which decide what the patent really means, not what the patent holder says it means when coming forward, but what it actually means, effectively can strip away claims as the plaintiff has alleged them, and can often define what the outcome of the case. Is that a fair statement that Markmans often end cases, or effectively end cases?
I think with the qualification of often, yes, and in fact, the best proof of that is that's often a point at which you see settlements or indeed interlocutory appeals, because it's dispositive.
So when we're looking at this tool created by Congress that has over 200, approaching 250 judges today working on, it is a tool, and correct me if I'm wrong, that is fairly similar to other tools, but it has a couple of advantages. It's open and transparent if properly conducted. It has experts who specialize in it, which Article III judges have a hard time being because they have other cases. And the reality is it is less expensive, quicker, and has a narrow scope of what it is to decide.
Yeah, I think that's true. And in fact, I would point out that a lot of the concerns that are being addressed at this point were brought up in oil states, and the Supreme Court explained how the particular nature of this process, it's basically a review of an expert agency's product that is simply getting re-reviewed makes perfect sense and doesn't implicate the kinds of Seventh Amendment concerns that might.
Now, lastly, for the person behind you whose patent has been invalidated, and my sympathies, because that it hurts anytime you lose a claim that you believe should be meritorious. If that happened effectively in a Markman or in an ex parte reexamination, the outcome would be the same. There would be no Fed Circuit appeal, correct?
No, well, I think there would be, both re-exams and district court cases provide routes to Federal Circuit review, but then, as Judge Smith pointed out, if a case isn't instituted, the patent owner's already won, and if it is instituted, whoever wins or loses has a route to the same Federal Circuit review.
So she's not being denied that capability, simply has to avail herself of it.
No, as somebody who's represented many patent owners at the Federal Circuit, I know that they review the cases in great detail. In fact, if anything, a criticism of the Federal Circuit is it reweighs facts perhaps more than an appellate court should. So the idea that the Federal Circuit does not look at the facts is totally inconsistent with my 30 years of experience with the court.
Thank you. Yield back.
We will now turn to the gentlelady from Minnesota, Ms. Fishback, for 5 minutes.
Well, thank you very much, Mr. Chair. And I guess, you know, I know this is going to be a difficult question, or maybe not difficult, but maybe more expansive than 4.5 minutes that I've got. You know, what do you, and this is to all of the witnesses, and what do you think Congress can do to correct the issues raised in the GAO investigation, and both maybe in the short term and the long term? And that's open to anybody. So if someone would like to jump in, or any of the witnesses.
So I would say from GAO's perspective, certainly we think that bringing more attention to the need for transparency in decisions is really important, including being able to identify whether the opinions that are issued are that of the 3-judge panel or perhaps other parties.
And legislatively, you think we could accomplish that?
There are probably legislative avenues to do so.
Okay, all right, thank you.
So
Do any of the other witnesses want to get into that and maybe?
yes, I would. One option that should be considered by Congress is the creation of a tribunal instead of the existing structure of the PTAB. That is, that it's no longer part of USPTO, but is an independent adjudicating entity in which the director of PTO would become a party and could appear on the side of either litigant, but that otherwise the process isn't controlled by the USPTO at all. So, I mean, as an example of that, there's numerous examples, but you might think about the tax court. So if you have a tax dispute with the government, you're not litigating it before the IRS. You're litigating before an independent adjudicating body called the tax court, and the IRS is your opponent. So in general and really around the world, this idea of the independent tribunal is an appealing model.
Thank you very much. And Mr. Torkson, and forgive me for mispronouncing the name if I did, but do you have anything to add? Because I know that you touched on a few things earlier, or kind of talked about a few things that I'm just wondering, from your perspective, are there things that Congress could do in short term and long term?
So I'm kind of an agnostic on this. I think the one real thing that needs to be done is a culture reset as a minimum. And we've talked about how a sort of a surgical requirement for transparency is probably necessary. Beyond that, you know, there's so many possibilities. Congress solved this problem in 1927 and then inadvertently messed it up with a civil service reform in the 70s. So you could go back and make everybody a PAS, which was the old way that it used to work. But the other, there are all sorts of possibilities. I even give examples of moving them as Article I judges into the judiciary. There are lots of possible choices. There are pluses and minuses to all of them, but transparency really is a necessary factor of any solution.
If I may offer.
Absolutely.
So first, my views on all the things I've spoken to today are my own and not that of Ecolab or anybody else. I should, that's entered in the record, but I think I should state that as well here. I think this is a rare instance in which the solutions for Congress to follow have been spelled out somewhat more explicitly by the Supreme Court than in other instances. Presidential appointment of the judges is one route. So that's solution number one. That may be thought not the right solution for a variety of reasons. Another is to have review, but make sure that is with inferior officers not appointed by the president, review of their decisions that's entirely consistent with all the things we're concerned about, due process, transparency, and the like. Maybe the mechanism already is part of what the system has in it. The director decides in a case where the decision, the prudence of it is, there's some misgivings about that, to have the case reheard on rehearing by another purely independent panel, with which the director again, where the director again would not interfere with the independent determination. That maybe is easier if the tribunal operates outside the agency, or maybe mechanisms like that without the director possible outside the agency, but that's the other path. Review, but with a review that is transparent and involves no interference, as Judge Torkson was saying earlier. No ex parte communication ought to mean no ex parte communication, and transparency, every communication being on the record should mean every communication being on the record.
All right, well, thank you. And thank you to all the witnesses for being here today. I appreciate that. And I know you had to wait while we ran for votes, but thank you very much. And with that, Mr. Chair, I yield back.
I thank the gentlelady. Next, we will hear from the distinguished gentleman from California, Mr. Issa, for 5 minutes.
Thank you. The gentleman from Kentucky has a UC request, if we could.
Mr. Chairman, I ask unanimous consent to submit 4 documents to the record. The first is one I referenced earlier, in case we didn't get that in there, titled I can't even say the word, Pecuniary Interests of PTAB Judges, Empirical Analysis Related to Bonus Awards to Decisions. The second one is How Google and Big Tech Killed the U.S. Patent System. The third one, USPTO response to FOIA confirms there are no rules of judicial conduct for PTAB judges. And the fourth one, I'd like to submit the 7th Amendment to the Constitution for the record, because I believe that the PTAB is an egregious violation of it. Thank you.
Without objection, so ordered. Gentleman is recognized.
Thank you. If we could start again. Thank you. I think I'm the closing act here. And so I want to bring back some questions that I think particularly my 2 judges, former judges, are equipped to answer. First of all, when we look at PTAB today, is it in fact an organization that has a lower reversal rate than Article 3, at least as to the items that they have before them?
I think the answer to that is yes.
And is it quicker, notwithstanding that you might be in 2 places, but the process is fairly quick?
There's no question that's true. The Congress did the PTAB the favor or the non-favor of requiring written decisions in no more than 365 days. I think at least during the period I was the chief judge, we did not take 366 days in even 1 case.
So we have a response that is quicker and more accurate, but perhaps lacks transparency. Because it's quicker and more accurate, it's fair to say that, for, at least on those decisions, it's less expensive for both sides, right?
I would say that's generally true, just because the issues are so much narrower.
So knowing what's good about it, we have some challenges. And I'm going to ask one question to both of you. The chairman and I have talked about a lot of potential fixes, including the tribunal and other options. But is it fair to say that in a previous court decision, when bankruptcy judges, Article I judges, were moved to fall under the federal court system, it both solved the problem and elevated the respect for the decision process?
Yes, I think that's true. I would say that my experience confirms GAOs, which is that generally people believe that they are getting very high quality decisions from the board. And that's certainly my belief.
The bankruptcy court solution, Article I judges in the Article III world certainly has proven over time to work. I think the question is, does it work for this circumstance? And that's the matter before your esteemed selves.
Well, you know, in somewhat of a closing statement, the challenge we have is with the GAO's preliminary findings and what we hope to be some additional with whistleblowers that have come forward that we hope to bring public at the right time. We do believe that there needs to be congressional action. Now, we want to do it measured, we want to do it carefully, and in light of the Supreme Court, we want to do it constitutionally. So that gives us several avenues. Obviously, additional confirmed individuals who perhaps would be term and would not be as politically affected, certainly is one possibility, and the chairman and I have discussed it. The idea of moving to Article III oversight is another one, and because of the size of this court, it would bode well for it. Unfortunately, because of the size and complexity of it, the question is, would we remove them from their technical environment, from an environment that is synergistic to what they do? All of those will have to be considered. The one thing that I will ask as a closing question to each, to the extent that you can answer it, if we were to scrap 250 judges and growing, what would be the impact if all of that work was moved back to the Article III courts?
If I can start, I would point out that that's not really been a solution that's existed since the 1830s. The PTAB, since the office since the 1830s, has reviewed and had trials between competing interests and has even taken out patents and patent interferences.
Oh my goodness, so you're telling us that it's not new and that what Mr. Massey is saying, that we should just go back to the way it was, wouldn't actually take it all to the Article III the way he implied? Tell me more, please.
As somebody who actually liked patent interferences, which may make me an extreme minority, yeah, patent interferences covered all patentability issues and even covered inequitable conduct and invalidated patents as part of that process. The AIA has expanded the scope, but one of the reasons why the AIA was adopted is because it was very clear that the interference process was being abused to get a post-grant review process that otherwise wasn't available.
Mr. Chairman, that's probably the best place to close. The recognition that this is an evolution, that we have been here every 4, 10, or 20 years for more than a century, and that, yes, we might be here again in 4 years, but that this is a process that has evolved because of past problems, not because somehow there was a new invention of a different remedy. And I think our witnesses have been very helpful in us making the record complete, and I thank the chairman for his calling this hearing today, and yield back.
I thank the ranking member, and this concludes today's hearing. I want to thank all of the witnesses for your testimony today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And without objection, the hearing is adjourned.
Thank you, Chairman.
Thank you.